just get him on stage, if you don't mind, so we can get underway. So honoured guests, ladies and gentlemen, welcome to Weber Wenzel. My name is Christo Els. I'm the senior partner at Weber Wenzel, and it's an honour hosting you this evening for this discussion. We're doing so in partnership, obviously, with the Thabo and Mbeki Foundation. We're very, very privileged and honoured to do so. So thank you for joining us, in particular during Africa Month. You would know in the past, in Africa Month, we've really been very reflective on our heritage as Africans on the continent. But we think this month, and in particular some of the events we've had celebrating the month, is a little bit more reflective and just looking at ourselves a little bit more carefully. Despite very significant strides that we as a country and the continent as a whole have made in enhancing democracy on the continent, in strengthening our institutions, reducing poverty, helping with inequality, etc., we think there's still work to be done in relation to securing justice for all Africans, and irrespective of their geopolitical circumstances, and to really realize their potential and our potential. And we think that remains a challenge, which is why, it's a topic of tonight's discussion. We're very fortunate tonight to have very accomplished and distinguished members of the panel, and we think that it'll be really valuable for them to share their thoughts and perspectives on the International Criminal Court, and in particular on Africa's quest for justice. This evening, I'm going to hand over to one of my partners, Octavia Ampafu-Anti. Octavia is a partner in our dispute resolution practice, and she's going to introduce you to our panel members. And it's just a coincidence that Octavia also worked before she joined us at the ICC. So thank you for being here. We hope we have a very fruitful discussion and an interesting discussion that really helps to stimulate the debate in this regard. Octavia.
Good evening, everyone, to our distinguished guests. Thank you so much for joining us this evening and gracing us with your presence. I'm sure it's going to be what's the right word? Heated discussion, as the topic of ICC in Africa always is. I'd just like to briefly introduce the panelists that are going to be here this evening. Unfortunately, there have been a few schedule changes. Courtney Griffiths is not going to be able to join us as he got stuck in London. His travel arrangements didn't work out the way he had hoped, so he obviously sent his apologies. And Professor Alexandra Miziev, who will be joining us on the panel, is also in transit at the moment in the wonderful Johannesburg traffic, and he will hopefully be joining us very shortly. Professor Miziev, of course, is the head of department of, and I believe that could be Professor Miziev walking in right now. Good evening and welcome. If I'd known that all I had to do to make you appear was just invoke your name, I would have done it a while ago.
It looks like he was waiting for me.
I was actually about to introduce you in absentia.
But you know that trial in absentia is not allowed, so I have to be tried.
Actually, maybe that's what we need at the ICC. Maybe everything would move faster. So Professor Miziev, of course, who's just joined us, is the head of the Department of International Law at the University of Management TISPI in Russia, and he's also a former member of the Association of Defense Counsel practicing before the International Criminal Tribunal for the former Yugoslavia, ICTY. Of course, Professor Miziev will have a lot of interesting insights to share with us, also stemming from the ICTY experience, which of course was one of the first experiments with international criminal justice in the modern era. We also have joining us tonight Murray Hathorn. Murray is a partner at Weber Wenzel. He leads our pro bono practice, and he has the perhaps a dubious distinction of having led the team that dealt with the matter relating to the arrest, or rather the non-arrest, of the former president, the current president of Sudan, Omar al-Bashir, and that debacle that unfolded during the course of last year. And he'll obviously share local insights around enforcement and local enforcement of ICC arrest warrants. We also have with us the Honorable Dr. Ahua Melo, the former Minister of Information and the spokesperson for the government of Cote d'Ivoire under President Laurent Gbagbo. And of course, Dr. Melo is eminently qualified to speak on the issue of the ICC, as Cote d'Ivoire, as most of us will know, is embroiled in issues relating to the ICC at present. So he can give us that perspective on the domestic impact of the ICC's prosecutions. So just a few words on why we're doing this, and I'm sure that most of you that have taken out your Thursday evenings, which some of you could be out enjoying yourself some way, to be here to discuss this topic is because it really is a burning topic that requires Africans to visit and revisit on several occasions in order to come to a place where we are all comfortable and on the same page about how we should be moving forward as a continent on the issues of Africa's involvement in the ICC. As we would know, earlier this year, there was talk of the African Union and all member states within the African Union withdrawing en masse from the ICC, and that was, of course, precipitated by the numerous incidents that have happened over the years where Africans have been brought before the ICC. At present, there are 10 situations that are under active investigation by the ICC, and of those, 8 are situations emanating directly from Africa. So the issue of Africa and the ICC is one that we definitely need to look into and debate. And without further ado, I will hand over to the moderator for this evening's discussion, which is Ms. Otilia Manganidze of the Institute for Security Studies.
Thank you very much. And again, just to welcome everyone to this event and for joining us in what has already been said might be a heated discussion, but one hopes that maybe it won't be so heated. I am going to, not having spoken to my panelists beforehand, but I will ask that they limit their remarks to between 12 to 15 minutes so that we get the full benefit of their introductory remarks, but also so that we do have time also for a discussion after that, given that we did start almost an hour late. And before I turn to my panelists, and it's quite easy when all your panelists are men, I don't have to say ladies first, I'll just pick them at random. But before I turn to my panelists, and in many ways in terms of introducing some of the key issues, already there has been, in introducing the topic, issues around international justice or justice at the International Criminal Court. The theme of today's panel discussion is around the ICC and Africa, and Africa's quest for justice more specifically. So it's two things. It's the work that the International Criminal Court does, and how, if at all, that complements the work that Africa does, and the interplay in that regard. Obviously, speaking to the ICC itself, it does have jurisdiction over war crimes, crimes against humanity, and genocide, overall as thematic focus rather than a geographical focus. And I think that is something that is important to note as we go into this discussion, that while 8 out of the 10 situations before the International Criminal Court arise from African situations, its jurisdiction relates to very clear substance matters, so war crimes, crimes against humanity, and genocide. What we do have is a great group of panelists, 2 of them coming from the African continent and 1 from a bit further afield, perhaps explaining his delay in getting here. And so we will hopefully hear some lessons or some thoughts to reflect on in terms of justice at an international level, justice coming out of Côte d'Ivoire, in South Africa, and then some lessons from the International Criminal Tribunal for the former Yugoslavia, and some reflections in that regard. And in many ways, we also need to be reflecting on what time in history we are having this discussion, and in that to look at whether or not there are conflicts arising on the African continent and what needs to be done to address them. But in speaking to that, and perhaps why I'm also the only person who doesn't work for the defense on this side of the room, is that speaking to fairness of process, due process, equality of arms as well within that regard. So it's not just about meting out justice, it's about meting out the right kind of justice, and ensuring that people are held to account. And before I hand over to my panelists, and perhaps to speak to something that is not the ICC related, on Monday, the 30th of May, literally 2 days ago, the Extraordinary African Chambers in Senegal convicted the former president of Chad, Hissène Habré, for crimes against humanity committed during his term in office in 1982, from 1982 to 1990. Between 1990 and 2015, very little was done in terms of actually beginning a process to prosecute him. And in many ways, this was not because of a lack of desire for the prosecution to happen, but rather something that hopefully my panelists will speak to is around whether or not there is political will, political commitment and dedication to actually bring people to account. And in speaking to that, which kinds of people is there political will to bring to account? And maybe we will reflect also on the current ICC's court role. Hissène Habré was sentenced to life, and he has time to appeal his decision. But what is important in many ways in terms of what the judge president of the court said was not only was Hissène Habré himself complicit in the crimes for which he has been convicted, but that he created an environment of impunity. In reflecting on how we mete out justice, we also need to question whether or not we support or create environments of impunity in the name of defense. That being said, and maybe I will start not on this side because we've heard two people from Weber Wenzel already. So to start from my far right with Dr. Awa Domelo from Côte d'Ivoire. Je vous donne la parole.
Thank you very much. First of all, I'm not a lawyer, and then I'm not going to speak about the Statute of Rome. Second, I'm not an English speaker because I come from Côte d'Ivoire. There we speak French, and then I'll try to speak English because all of you speak English. And then you have to apologize me if sometime French word come into English sentence. Thank you very much to be here. What I want to say about the request of justice in Africa, particularly in Côte d'Ivoire, about the ICC. If they ask me if I agree with what is going on in Côte d'Ivoire with the ICC, I can say right now I don't agree. The request of the justice is not okay there. Why? I'm going to explain why the situation is so critical in Côte d'Ivoire. Because justice, the most important thing in justice is the context. Then I'm going to describe you the context, and after we are going to see if there is justice in Côte d'Ivoire or not with the ICC. You have to know that Côte d'Ivoire has been independent in 1960 with a president who is called, everybody know him, Félix Houphouët-Boigny. But 1 year after the independence, he gave back the independence by signing some agreement with the former colonialist, which is France. And the content of this agreement was very, very, very specific. And I'm going to read you the content of this agreement. And you will see that 1 year after the independence, Cote d'Ivoire lost its independence. The agreement is delivered like that. The French Republic shall be kept informed about the programs and projects concerning all export of raw material and second-class strategic products outside the territory of the Republic of Cote d'Ivoire, the Republic of other countries like Dahomey and the Republic of Niger. Regarding such material and product, the Republic of Cote d'Ivoire, the Republic of Dahomey and the Republic of Niger, for the purpose of defense, reserve priority sale to the French Republic after meeting the needs of their domestic consumption and are supplied by priority by the French Republic. What does that mean? That means that the conditional consideration for military assistance under the defense agreement signed with Francophone African countries after independence. Through this agreement, France established military bases in its former colonies to protect, it's supposed to protect the regimes in power, and in return, a self-proclaimed owner of raw materials dictated the share of income according to the independent states and the population, but grants itself a monopoly in import and export and investment in its former colonies. What does that mean? If Cote d'Ivoire wants to buy something outside France, he has to ask first to France if he can buy. If he wants to export his raw material, he has to ask France first if he can export outside France. That means that Cote d'Ivoire became 1 year after the independence a department of France. Then a new policy can appear in Cote d'Ivoire if we have not the authorization of France. This is the context. And it is against of this context that a new party has been created by Mr. Laurent Gbagbo. He wanted to build a country without this kind of agreements which link the country to another country. This is the main reason of the creation of the Ivorian Popular Front by Laurent Gbagbo. He fight pacifically without using guns, without using arms. He fight pacifically, speaking for the true independence of the country during several years, 20 years. And after the multi-partism period in 1990, he became president in 2000. And when he became president, he tried to implement his political vision. And the first trip of Laurent Gbagbo was not in Paris to ask the permission to go to China. The first trip of President Gbagbo was in China to get a new agreement with China because of the situation. He needed a lot of, because he wanted to open the country to all the other countries in the world who can help Cote d'Ivoire to develop his potential, his economic potential. That was, I think, in my point of view, the main crime of Laurent Gbagbo. If we want to speak about crime, this is the main crime. Because according to this agreement that I told you right now, he cannot go anywhere to sign any agreement with the will of Paris. Then what happened after this trip? 2 years after this trip, some terrorists trained in Burkina Faso, which is a country close to Cote d'Ivoire, armed by France and with the financial support of France, attacked the country. 2 years after the presidency of Laurent Gbagbo. Then nobody wanted to help Laurent Gbagbo to push away the terrorists who attacked the country from Burkina Faso. They say that Laurent Gbagbo has to discuss to discuss with the rebels and get an agreement with the rebels. He accepts everything because he cannot do anything because France, who's supposed to help him, according to the agreement that he signed, who's supposed to help him to fight the terrorists, France said that he cannot find the terrorists, he cannot fight, his army in Cote d'Ivoire is not there against terrorists. Gbagbo Laurent has to discuss with them. This is what he did. He discussed with them, he found an agreement, and the rebels with their guns, they become minister. They become minister. Some of them doesn't know anything about administration. Sometimes they didn't never go to school, but they become minister. And this was the situation. And from 2002 to 2010, then some discussion goes away because the terrorists first of all asked Laurent Gbagbo to accept that Mr. Ouattara can be candidate in Cote d'Ivoire because the law of the country cannot allow Mr. Ouattara to be a candidate elected in Cote d'Ivoire. And the terrorists asked Mr. Laurent Gbagbo to accept this situation against the will of the Constitution. And the problem has been solved here in Pretoria. Because there was a meeting between Laurent Gbagbo and Mr. Ouattara in Pretoria, and then they discuss, and Gbagbo accepts Mr. Ouattara to be elected in Cote d'Ivoire. And then after this agreement, he become elected in Cote d'Ivoire. And then he can be candidate. It is after that the rebel accept to let Laurent Gbagbo ruling all the country, because from 2002 to 2010, the country was divided in two. One part for the rebels and another part for Laurent Gbagbo. And after this agreement, Laurent Gbagbo can rule all the countries. But the terrorists didn't want to give up their guns. They have their guns, they control the country, and they are inside the government, and Laurent Gbagbo accepted to go to the election. And after the election, Gbagbo Laurent win the competition. Again, he win the competition, he has been declared president of the country, but France refused to accept that Laurent Gbagbo can be the president of Cote d'Ivoire. And then they took a resolution against him to fight him again and to withdraw him from power, and he went to the ICC. In the ICC case, Laurent Gbagbo didn't ratify. The ratification of the ICC statute was not done in Cote d'Ivoire. Yes, because there was a contradiction between the statute and our constitution. We have to change our constitution before accepting the statute of Rome. We couldn't change the constitution because of the situation in the country divided in two. To change the constitution, we have to go to the vote because it is a constitution. If we want to change, there is some rules to change the constitution. And then if we cannot change the constitution, then we cannot be member of the Statute of Rome. But they didn't consider anything of us. Laurent Gbagbo has been taken from his country to the ICC. And after that, they changed the constitution when Ouattara became the president, and then they go to the ratification of the Statute of Rome. And then everything was upside down in the case of Cote d'Ivoire. And after that, they went to trial. But when we follow the situation in Cote d'Ivoire, who is the criminal? People who took guns to attack the country in violation of the constitution of the country, they are the first criminal. But after that, the crimes began in 2002 to 2010 in all the area controlled by the rebels. A lot of crimes has been committed there. We didn't see the ICC. Even during the attack of the last period in 2010, the first day of the attack, the rebels kills 1,000 people in one day in the same area. It was like a genocide because it is the same population in the same area who has been killed. We didn't see the ICC. Therefore, around the residence of the president, a lot of young people was around the president to protect the president. They are all been killed. Until today, we don't know where they are. They have been killed. And then if we want to speak about justice, who commit crime in Cote d'Ivoire? Who attack the country? Who finance the attack of the country? Who give the guns to the rebels? All the questions, we know the answer. First of all, the rebels have been trained in Burkina Faso under the President Blaise Compaoré. Second, the guns has been provided by France. We know exactly who was the president of France. Third, the finance comes from the cocoa businessmen. We know exactly who financed the attack of the country. We know everybody. But today, who is at the ICC? The person who has been attacked is at the ICC. And the person who has commanded all the attack is free. With all the rebels, they are free. Some of them are ministers, some of them are managers, some of them they are ruling the country. And the crimes are still committed in Cote d'Ivoire. Until today, I'm a victim because I cannot go to my country. I was the spokesperson of the president, and I'm accused to make crime against my population. I was not a bearer of guns. I just bear the words. I speak. I was the spokesperson, but right now, if I go in Cote d'Ivoire, I'll be in jail. And those who attack the country, they are free. This is the situation. And then in the case of Cote d'Ivoire, we cannot talk about justice. And if we want justice, first of all, Gbagbo Laurent has to be free. And second, we have to try another way to solve the Ivorian problem. If we don't have another solution to solve the problem of the request of the justice will remain. And then all the criminals are freed now. Now, how can we talk about justice when we know really who attacked the country, who committed crimes, they are free, and the victims are outside, in exile or in jail? This is the situation. And then if we want justice in Cote d'Ivoire, we have to go. We have to choose another way. The ICC is not the way of justice in Cote d'Ivoire. It is what I want to say, first of all. And then after, we can talk about the issue of the justice in Cote d'Ivoire.
Thank you very much for your remarks. And perhaps we will have some questions later on in terms of what is Cote d'Ivoire itself actually doing in terms of bringing justice within Ivory Coast if, as you say, the criminals are known to you and they are still in Ivory Coast. Obviously speaking quite passionately as the former spokesperson for the former president of Ivory Coast, Laurent Gbagbo. I'm going to turn now to Professor Alexander Mezea, who will speak, I hope, on some of the lessons from the International Criminal Tribunal for the former Yugoslavia, but also if you can share some reflections on the ICC and Africa's quest for justice.
Thank you very much. Sanibulani.
Wow.
I'm also not English speaker, so sorry, my English will be confused with Samzu. First of all, I would like to thank you.
Neither am I.
Thank you for Foundation, Thabo Mbeki Foundation, for organizing such an important conference, because the topic of today's conference is not the topic of purely academic interest. Today, Africa is on the front line for the battle of independence. It's kind of new battle for independence because the International Criminal Court, and let me today try to speak about the international system of international justice, so-called international justice, is trying to change the rules of international law. So I would like to use my experience working with International Tribunal for the former Yugoslavia, putting the ICC in the context of the existing system of international criminal justice. I would like to share with you several examples of what is really going on in daily work of international tribunals. And I have a right to talk about international tribunals as a whole because having no formal connection between each other, in fact, they constitute the common system, and I will try to prove it during my presentation. The position of defense is very difficult in these tribunals because sometimes the defense counsel even could be not only degraded but even arrested if they try to conduct a real defense. And the example of the case of the former Vice President of the Democratic Republic of the Congo, Mr. Jean-Pierre Bemba, is quite a sharp example, because all of his defense team was arrested. Reason? Because defense was about to present an evidence that the prosecution is bribing prosecution witnesses. Okay, if you want some detail, all African members of the defense team were arrested. One non-African member was not arrested. I probably skipped the problem of the defense counsel, which sometimes even work against the accused. But generally speaking, the position of defense is very, very difficult. For example, you could not talk about the health of your client. And nowadays, it is known that the health of the President Laurent Gbagbo is not good. It was several attempts to ask for his provisional release. But the problem could not be publicly discussed because defense is not allowed to talk about this. The defense is obliged to sign the special agreement when they could not say anything about this, even if their client is dying. I'm a little bit more free to talk about this because I'm not professional counsel, I'm from academia. That's why tribunals so don't like me, because they don't have a means to suppress me and to destroy the career. But the professional counsel sometimes in a position that they're really afraid of tribunal. Unfortunately, we are facing such a problem of not only not providing the adequate medical help to the accused, but even we have several cases of assassination of the accused in the prison of International Criminal Tribunal for the former Yugoslavia, which is the same prison for ICC. So I personally investigated the assassination of the former president of Yugoslavia, Mr. Slobodan Milosevic, who was poisoned. There is evidence about this. But the tribunal refused to accept this evidence, and moreover, they eliminated me from the council and do not allow me to defend, for example, General Mladic, who claimed that I should be his defense counsel. So I'm preparing you for me using a very, very hard terms. Sometimes using such a hard lexicon, provoking disbelief or provoking doubts. But I think it's very important for us to use a right terminology. If somebody commits a crime, it should be said so. And as a lawyer, I'm claiming that the international tribunals and the staff of international tribunals, the prosecution of international tribunals, they commit crimes. Issuing of the indictment, which is already known as a false one, it is a crime. It is a crime in many jurisdictions. In Russian criminal code, we have a specific article that if the prosecutor knowingly issued the false indictment, he is subject for prosecution himself. We have nothing like this in the international criminal system. Nowadays, we are witnessing a very interesting situation when it is created a group of people, I call them untouchable, who could commit any crime, but they never could be prosecuted. It's a very interesting situation when the head of states supposedly lost their immunity or absolute immunity. But in the same time, it was created a group of untouchables with absolute immunity. So international prosecutors and judges are absolutely immune. Oh yes, there are some rules, internal rules, that if their colleagues found them in contempt, but you know it's never happened because they act as a common group. But nobody from outside could even raise the question of their crimes. So I'm coming to my first point I would like to suggest you for today's discussion, that international criminal courts and tribunals, and this is a point connected with my suggestion to use a right terms, because sometimes the not right terms are mislead not only those who listen to us, but mislead even ourselves. So these international criminal courts and tribunals are not international. Because what means international? International means that a certain institution is created by members of international community and implemented the common policy of the member states. If member states are not agreed with that, it's not obliged to this member state. But in the case of the so-called International Criminal Court and other courts, we have in fact the institution of global power. And I would like to suggest us to use this terminology because just not to mislead ourselves. And the global power have totally different agenda. I will talk about this a little bit later. And the second point I would like to suggest is that all the problems in the activity of ICC and other courts are not shortcomings, they are not side effect, they are not collateral damage. And this is very important to understand in the context of the latest decision of African Union that we are withdrawing, but we will stay if. And this if is very dangerous because this if means that ICC could be reformed. The ICC is just working badly, but the idea is great. So my second point is that would be a big mistake from our side to believe that all these problems is just a collateral damage or side effect. No. All the institutions of international criminal justice were created for totally different aims than restoration of peace, and even justice, because I think sometimes we genuinely believe that if we resolve the problem between, or dichotomy between restoration of peace and justice, this problem of ICC could be resolved. No, I don't believe, and I hope that we have enough time to discuss this. Neither restoration of peace, neither even justice was the point and aim in the establishment of this institution. Then another question arises. What are the aims of these institutions? And before I receive that I have 2 minutes only, I think I should come exactly to this point. The first aim of this institution was removal of head of states and the judicial decoration of such a political decisions. You know what is interesting? When we put the ICC in the context of all other international criminal tribunals and courts, we will realize that they're acting so differently. They don't have any formal coordination. So sometimes when you look at their activity, it's total mess. But when you really put this aim as a real one, everything becomes logical. They are very consistently working on this agenda. And the second aim of this institution is to destroy international law and to create global law. Sometimes we as lawyers are feeling very confused when we read the judgments of or even provisional decisions of international criminal tribunals, because they are obviously violating law. Sometimes such a violation of law even openly proclaimed. Let me just give you an example of expression of Judge Court of ICC, who, while acquitting Mr. Chui, in the case of the Democratic Republic of the Congo, said the following. I especially made a pause that you enjoy what he said. He said, Mr. Chui, the fact that we are acquitting you does not mean you are innocent. So this is something new. And you really will be confused listening such things only in a case you still believe that ICC is a judicial institution. Yes, you will be very much surprised to realize that several judges of ICC not only never been judges in their career, but they even don't have legal education. You could check the website of ICC and verify that I'm telling you truth. Only truth and nothing but the truth. Of course, they did not say that in this way that judge didn't have a legal education. No, they didn't say like this, but they put it in a way just not to mention that judge ever had education. So, but when you realize that the idea of these tribunals was the destruction of existing international law and creation of new law, then it became all became very logical and consistent, because judges are writing their own law. And the first tribunal that started this practice was the International Tribunal for the Former Yugoslavia. It openly started to rewrite international conventions, and defense was not even heard. And thus, using the so-called idea of judicial precedent, and other courts just start to cite other courts' decisions, thus producing so-called impression that this is a law that they're producing. The main question is what to do. I have my suggestions, but I have only 1 minute. So probably we will put it on even -5. So maybe I have a chance to share with you my suggestions, what Africa could do in this situation in maybe second round of our presentation.
It's not a boxing match.
Second round of presentations.
Thank you very much for your presentation, and I think particularly to your South African audience, speaking specifically about the role of the judiciary in lawmaking and the role of the judiciary in creating jurisprudence and setting precedents. It's something that I think South African lawyers would be quite interested to know whether or not you believe that judges should not be making law or developing laws or developing jurisprudence. And then also some reflections in not the second round of presentations, but when the discussion happens as to whether of the 87 coups in Africa, since 1950, how many of those have been at the hands of the International Criminal Court. I'm going to then turn to Moray Hawthorne, who is a partner here at Webber Wentzel, to share some reflections on South Africa and the ICC.
Okay. Well, I'm of the panelists here this evening, I'm the one person, perhaps, who has some faith in the International Criminal Court, in the sense that my job has been to secure the arrest of President Bashir.
I sat you in a good position away from
and his referral to the International Criminal Court. Of course, I personally, my first, I had an experience in which I came into contact when I was at a public interest law organization here in Johannesburg with the bishops from South Sudan. Some 20 years ago, they came to our office at the Legal Resources Center, where I then was, asking for help because of the grim situation which the people of South Sudan were facing. Little did I know that about 15 or 16 or 17 years later, I would be instructed to bring an application in court to secure the arrest of the person who they were complaining about at that time. I must say one felt a great sense of helplessness at that time. But the sense of helplessness having regard to what happened in the case hasn't disappeared, in fact. I think also one should not forget that the International Criminal Court had strong African support in its formation. And many African states have signed the statute of the International Criminal Court. 127 nations so far, with a great number of African states. It's also important, I believe, to recall that of the cases involving the prosecution of Africans, the majority have been referred by African states themselves. I was at the Assembly of State Parties of the International Criminal Court last year, and it was noteworthy to me that several African governments indicated their strong support for the court, including Mali, Congo, Democratic Republic of Congo, and Botswana, and perhaps there were others too. In fact, the foreign minister for Democratic Republic of Congo remarked how much they owed to the court. Because I think Congo, I think, has made many referrals of warlords to the court, some of which have been convicted. And so, I think that one also, in my humble opinion, has to bear that perspective in mind. It was noteworthy to me that Mali has signed an agreement with the court to provide the court with logistical support, ranging from holding people in prisons and so on, providing prison facilities to the court. President Bashir, on the information that I have, is responsible for the deaths of some 400,000 people in South Sudan, in the Darfur region, and he has been charged. One of the charges against him is a charge of genocide. In including torture and crimes against humanity. In 2010, when he was due to come to South Africa for the inauguration of President Zuma, it was made very clear to him by the South African government that if he did set foot here, he would be arrested and handed over to the International Criminal Court. And the statement of the South African government on the issue at the time, in my respectful opinion, is a model of clarity from which they subsequently departed. But it's also worth noting that a large part of the reason which they gave to defend their position was that this was a media that was invited not by South Africa but by the African Union last year to an African Union summit. It was the middle of June, Saturday the 13th of June, when he came into South Africa, and we brought the application that night. On the previous evening, the International Criminal Court had issued an opinion stating that the South African government would be obliged to arrest him if he came to South Africa for the summit. That is quite important in the context of the statute of the International Criminal Court, which states that in section 27 thereof that the position of a person is no bar to them being arrested and tried before the International Criminal Court, so that the fact that he was the sitting president of the country would not bar, or does not bar, anybody's arrest. Section 98, though, Article 98, speaks of a process to obtain the consent of the country concerned where that person is situated. So one has this kind of dichotomy. Legal commentators, though, have said, and we would argue that this is part of the international customary law, have said that really that the disputes, that the settling of issues around that tension is really for the decision of the International Criminal Court itself, and that decision had been given on the evening before his arrival in South Africa. And so therefore, I think the South African authorities, it was clear that their obligation, in my respectful opinion, was to arrest him when he arrived here and render him to the court, to the International Court, where it would be at that point in the International Criminal Court itself that he would be entitled to challenge its jurisdiction to hear his case. It was South Africa's duty to arrest him and render him to the court. That was our argument. I was instructed by the Southern African Litigation Centre, which is an NGO based here in Johannesburg, which provides support to people conducting human rights litigation throughout the Southern African region. And they've been involved in a number of important cases. And so I took on this case on their behalf, and we obtained an order on the Sunday. We brought the application on the Saturday night. It came before the court on the Sunday, and we obtained an order in terms of which President Bashir and the South African government was obliged to ensure that President Bashir did not leave the country pending the outcome of the application. The application was then argued, and that night, on the Sunday night, we came before a single judge on the Sunday, and that night the judge president of the Transvaal, Justice Mlambo, constituted a full court of 3 judges, including himself, as the president of that court. The application then was heard the next morning at about midday, and perhaps I should just tell you what the basic legal arguments were. First of all, there was a reliance on this Article 98. Secondly, there was a reliance on the Diplomatic Immunities Act, in terms of which it is stated that heads of state have an immunity. But we argued that under the Rome Statute, which had been domesticated into South African law, by the South African Parliament at a time when President Mbeki was President of the Republic of South Africa. It had been domesticated fully. That statute in express terms required the arrest because Section 10 sets out in detail the procedure, because the International Criminal Court had issued warrants for the arrest of this man, by President Bashir, on two different warrants of arrest, one of which had been endorsed by the magistrate in Pretoria, so that the arrest was permissible. And Article 10 states in categoric terms what happens when a person arrives in South Africa who is subject to an arrest warrant of the International Criminal Court. And Article 27 clearly states that the person's position as head of state is not a consideration. So, and that is basically the argument on which, that was a central argument which in fact was raised by us at the Supreme Court of Appeal level and was accepted by the court as being that it really had to look no further into the matter, and that on that basis South Africa was obliged to render him to the court. Of course, the state has now brought an application for leave to appeal that decision, which is pending before the Constitutional Court right now. Perhaps, of course, also another element to this is that the matter was referred to the International Criminal Court by the Security Council of the United Nations in terms of its duty to preserve world peace. That application, that of course the permanent members of the Security Council, some of them abstained, but there was no vote nay. So it was a decision by the Security Council to refer this matter to the International Criminal Court. There is a provision of the Rome Statute which says the following. Of course, let me just find it. Court, this is the Rome Statute itself under which the court was established, may exercise its jurisdiction with respect to a crime referred to in Article 5 in accordance with the provisions of the statute if a situation in which one or more of such crimes appears to have been committed is referred to the prosecutor by the Security Council acting under Chapter 7 of the Charter of the United Nations. Chapter 7 is the part of the Charter of the United Nations dealing with action with respect to threats to the peace, breaches of the peace, and acts of aggression. And so, having regard to that provision, we would say that the International Criminal Court clearly had jurisdiction over this matter. It must be remembered that, in a sense then, this court is part of the United Nations system with all its shortcomings and advantages. Another thing, which is I know that the Honourable Professor, in terms of the prosecution of the leaders of the former Yugoslavia, I happened actually to be asked to come to a conference in Bosnia some 15 years ago, where I saw at first hand the effects of the bombardment of the city by the Serb forces. It was a pretty grim business. The city was shot to pieces. The leaders of Serbia were arraigned for trial, and the court said the following. The prosecutor in that court was Richard Goldstone, one of our leading judges in this country. And in fact, it's an interesting story as to how he became the prosecutor. Because this was before the International Criminal Court was established, and they established this tribunal for Yugoslavia. The question was who was going to be the prosecutor, and they couldn't get agreement. And they'd gone through 10 candidates when Richard Goldstone, who had been at the Goldstone Commission investigating third force violence in this country. He went back to his post at the Supreme Court of Appeal when he got a call from Mr. Nelson Mandela, and he said, "How are you, President of the Republic?" In fact, and he said, "Well, I'm very glad to be back at this court. I'm very glad we finished the Goldstone Commission." And he said, "Well, don't hold your horses. Don't move too fast, because I'm going to put you forward as a candidate for the prosecutor for the Yugoslavia Tribunal," which in fact happened. So that the prosecutor in that tribunal was Richard Goldstone, one of our leading judges in this country. In the Furunzi judgment, I hope that is properly pronounced, it confirmed the Jus Cogens character of the crime of torture. Jus Cogens, that is specifically genocide, crimes against humanity, including torture and war crimes, which is the International Criminal Tribunal for the former Yugoslavia, held that a consequence of crime being designated as Jus Cogens norm, i.e. genocide, crimes against humanity, which would be rape, for example, on a systematic scale, including torture and war crimes, held that a consequence had the effect of every state being entitled to investigate, prosecute, and punish or extradite individuals accused of torture who are present in the territory under its jurisdiction. So that, in our view, would be a further basis of South Africa's right, indeed its duty, to have arrested al-Bashir and rendered him to the International Criminal Court. Before I finish, there were several other arguments. So the United Nations Security Council, under Resolution 1593, referred the Darfur situation to the ICC, and that's how Article 13, which I read to you just now, comes into force. And there's also the Genocide Convention, to which both South Africa and Sudan are signatories. Article 6, importantly, the contracting parties to the Genocide Convention agreed that the obligations under that treaty apply irrespective of the status of the charged person, even if that person is an incumbent head of state. One of the charges which is faced by President Bashir is torture. So therefore, under the terms of that convention itself, to which both Sudan and South Africa are signatories, South Africa has an obligation and a right to render him to the International Criminal Court. And as I've said before, although one has this tension between Articles 27 and 98, which 27 says that your status does not give you immunity, or it strips everybody of immunity who's charged with one of these crimes. 98, which says you need the consent of the state concerned. Legal commentators have said, in what we would regard as part of the current customary international law, is that that issue can only be decided by the International Criminal Court itself. And that therefore, if President Bashir wants to challenge the jurisdiction of the International Criminal Court, it is not South African courts which have the jurisdiction to do that. And so far they've upheld that position quite strongly. It's in fact the International Criminal Court itself. So I speak from a fairly limited perspective as a lawyer with a fairly limited experience of these matters, having really dealt with actually two cases. I have dealt with the case which came before our courts, and our Constitutional Court agreed that under the Rome Statute, South Africa is subject to considerations of practicality and reasonableness. Our police force, it domesticates those crimes. They are crimes in South Africa wherever they may be committed, and that our police force is obliged to investigate those crimes with a possible view either to extradition of those persons or to their arrest in South Africa if they ever set foot here, to stand trial in this country, and also as a part of being able to assist the International Criminal Court, or indeed any other court, any other regional court. I mean, obviously South Africa would be best positioned to investigate crimes committed here. And I just think one last word. people say, let's have an African court. That's fine. I support that fully. We already have an African court in the case of Habre, who has been convicted and sentenced to life in prison. It's subject to a right of appeal, of course, in an African court, the courts of Senegal, where the African Union passed a resolution that Habre should be charged for crimes against humanity within the Senegal court system. And Senegal passed a statute, which I have right here, which provided precisely for that. So that's an example of an African court which has brought somebody to justice. And I do not see that this is in any way, I think that this is to be applauded. It can be the beginning, I think, of an African court, of a regional criminal court. Africa can do it. It's been done. This is very good. And it can be expanded upon. And I know that the South African government wants to do that, and in accordance with an African Union resolution, I think. But having said that, there is absolutely no reason that it is entirely right and proper in the interest of international criminal justice for regional and African courts to be established for this purpose. But that doesn't mean to say that there should also not be an international criminal court. Because the point is to create impunity for leaders who commit these crimes. And to also have an international criminal court at the apex is a part of establishing a system, a global system, where people, even if they are leaders or presidents of countries, cannot escape trial and punishment. So therefore, I think that it's great to have an African court. We've had a very successful experience recently. It doesn't mean to say that the International Criminal Court should be done away with, or that Africa should leave that court. The two don't necessarily go together. In fact, they should have the court. We should have our regional courts, and we should also remain members of that court.
Thank you very much. It is quite difficult to regulate the time of your host, just in case he then chooses to throw me out and continue with the event without me. But I also, and I must, full disclosure here, I also gave him a little bit more time because of my panelist. He's the only one who made any mention of the victims, speaking very specifically of victims in Darfur and South Sudan, which my other panelists did not do. So I must say with full disclosure that he did get a bit more time because of that. And before we go into a discussion and answer segment, I'm hoping my hosts will allow us to go until 8:30, so that we can have a bit more in terms of a question and answer segment. But before we go into that, I think the one thing which has come out in terms of some of the interventions, and which is worth re-emphasizing, is really that the International Criminal Court, however it is couched and however it operates, at least in terms of its founding instrument, is intended to be a court of last resort. The question then, and something that Moray Hawthorne expounded a bit on, is then what role is there in terms of domestic processes? If the International Criminal Court is a court of last resort, then who is the court of first instance? Which are the courts that should be dealing with these crimes? Now, much as we can speak about a list of 10, 20, even 30 indictees, I think speaking in a room which has quite a number of lawyers, one would know that that is minuscule in comparison to the number of cases right now before, for example, the Gauteng division of the High Court. And if the Gauteng division of the High Court has more cases than the International Criminal Court, one can then assume that the Gauteng division of the High Court should have more cases, and that the International Criminal Court ideally should have as few cases as possible, so that whatever criticisms in respect of the way in which it operates probably do not arise, because justice is being done domestically. And I think one of the ultimate messages is when this justice is being served, it's supposedly being served in the interests of Africans themselves. And so be it a domestic court, be it a regional court, be it a court of the character of the Extraordinary African Chambers in Senegal, which was a domestic court in that it was in Senegal, but it received the support of the Economic Community of West African States and the African Union. Those are options. They are options for justice that are meant to complement each other. And with that, and before I take it to the other side of the room in terms of some questions, I'll pose one question which I had posed to you, but to restate it. If you can maybe briefly talk about what Côte d'Ivoire itself is doing in terms of bringing justice to Ivorians without speaking about the ICC. And then Prof. Alexander, if you can speak also in terms of what is happening within the countries of the former Yugoslavia in terms of bringing justice there without speaking about the ICTY. And I excuse you, I gave you extra 5 minutes.
Yes, what the country do in terms of justice, I cannot really speak in the case of Côte d'Ivoire right now, but when Laurent Gbagbo was in power, he tried to implement the new constitution of the country because he gets in power in 2000, and at the same period we got a new constitution. And in this new constitution, there is an institution which is called the High Justice Court.
Je vais le dire en français, je dois.
Oui, je peux le dire en français.
Bien sûr.
Et donc, en 2000, on avait eu une nouvelle constitution en Côte d'Ivoire qui prévoyait pour les cas de violation grave de la constitution ivoirienne et notamment des droits de l'homme, une cour de justice à l'intérieur du Parlement. C'était la haute cour de justice. Mais cette cour devait être mise en place sous le régime Thabo. Et lorsqu'il y a eu la guerre en 2002, eh bien, tout le processus de mise en place de cette structure a été stoppé. Et donc, on n'a pas pu mettre en place cette structure. Et donc, pour les cas graves de violation des droits de l'homme, eh bien, il avait été créé un ministère en charge des droits de l'homme, qui devait donc recenser tous les cas de violation des droits de l'homme et voir les cas qui pouvaient être jugés par le tribunal et selon les lois du pays. Ce qui a été fait. Maintenant, pour des cas graves comme les cas des rebelles et des terroristes, c'est comme ça qu'il faut les appeler, qui ont attaqué la Côte d'Ivoire, eh bien, la France a demandé expressément lors de la conférence de Paris qu'il y ait une loi qui amnistie l'ensemble des crimes commis par les rebelles. C'était la condition pour que la France apporte son soutien à l'accord qui avait été conclu entre les différentes parties. Et donc cela a institué une forme d'impunité.
Okay. Right. In 2000, under Laurent Gbagbo's presidency, the Ivorians, under the new constitution, sought to provide for a framework in which grave human rights violations could be dealt with, especially violations against the constitution or the letter of the law, and look towards establishing a Supreme Court which would deal with these grave human rights violations. But as people within the room might know, in 2002, Ivory Coast went into a civil war, and processes, or at least the efforts to establish this framework, were halted. Nevertheless, there is a ministry which is in charge of human rights, which is meant to deal with any violations of grave human rights in line with domestic law. Bearing in mind also some of the serious crimes that were committed by the rebel movements, and earlier, in line with the presentation that he gave, individuals who were dubbed as terrorists in Ivory Coast. But one of the major hurdles, at least under Laurent Gbagbo's presidency, he says, is that France demanded that there be amnesty provided for some of the rebels, and therefore creating a space for impunity, and that he cannot speak about justice processes at the moment in Ivory Coast, but rather justice processes that were meant to have been initiated under Laurent Gbagbo. Merci.
Ça, c'était sous Laurent Gbagbo. Mais aujourd'hui, sous le nouveau président, eh bien, ils ont instauré une sorte de justice qui ne juge que l'opposition. C'est-à-dire que tous les opposants au régime actuel sont considérés comme de potentiels criminels, tout simplement parce qu'ils ont supporté le régime de Laurent. Et donc aujourd'hui, nous avons 380 opposants, leaders, je ne dis même pas de simples militants, mais de leaders qui sont aujourd'hui en prison et qui n'ont même pas encore été jugés après 4 ans d'emprisonnement. Ils ont été tout simplement soupçonnés d'avoir commis des crimes. Ils ont été arrêtés et mis en prison depuis 4 ans sans aucun jugement. Voilà la justice telle qu'elle se produit aujourd'hui. Et nous avons appelé ça, en Côte d'Ivoire, la justice des vainqueurs contre les vaincus.
And at the moment, under the presidency of Alassane Ouattara, he says there is what is termed more specifically as victor's justice, in that the criminal justice system is really targeting only the current opposition in Ivory Coast, citing the example of 340 opposition leaders who were arrested and are in prison, and were imprisoned simply on the basis of suspicion and not on the basis of having faced trial. I'm going to now move on to Alex. I'm going to move now on to Alex to speak a little bit about justice in the territories of the former Yugoslavia.
Well, I could say that in 2 countries of the former Yugoslavia, namely in Bosnia and Serbia, there are trials that, considering the cases against those who are accused of committing crimes during the conflict in former Yugoslavia. Unfortunately, these cases are not well known. They are not broadcasted. The material are not so easily accessible, but there are trials. But maybe you allow me to answer to the question. You was not posed as a question but as a comment, but it needs to be responded. You said that we did not mention victims in our presentation. In fact, I did not mention indeed victims, not because I don't have a sentiments to the tragedy of these people, but only because I strongly believe that ICC has nothing with victims. In fact. So to speak about victims, it will be very misleading. It's like a rhetoric decoration of explanation why ICC exists. And I think it was very interesting comment that made by President Mbeki on his Africa Day lecture, when he mentioned that the problem of victims in international criminal justice. He gave an example of Uganda situation when the ICC issued indictment against Lord Resistance Army leaders exactly at the moment when that conflict was about to be resolved by political means, by presenting the amnesty to these people. And he asked, what about those victims who are suffering now, while it could be achieved political resolution of this crime without justice or so-called justice? So ICC and some commentators, they don't have sentiments to these victims. So I think that talking about victims will be not a really good idea for us. It will lead us to a different direction. Or let's ask me the question, while the certain organizations claiming to arrest al-Bashir here in South Africa have a sentiments to the victims of Darfur, but don't have a sentiments to the victims of the war, which Sudan will proclaim to South Africa, and South Africans will die in such a war, including, for example, already in Sudan, situated in Sudan, soldiers on a peacekeeping mission. So I think that sensitive matter just should be avoided because it has nothing with ICC.
I'm going to hand over to the other side of the room for your questions as well as your comments. Please do keep your questions as well as your comments as brief as possible and as clear as possible, bearing in mind that our panelists will also have to respond. So I will hand over to you. If there are any questions, there's one over there. So I'll start with you and then the gentleman at the back.
Thanks, and thanks to our panelists as well. Just quick ones. I think what we have learned from the discussion that has been presented by our panelists, which is of course there's always been our suspicion that there's nothing international about the International Criminal Court. Its main mandate is to deal and to manage or probably recolonize Africa. From what this is what we're picking up, but which this also what we are observing from a distance. At least now we can see these things and you can present it to us. But also to say that I think the main things that as much as we want to see or be part of the ICC, at the end of the day we are saying we want transparency. It cannot be one-sided, whereby others, they are above the law or they are law unto themselves. They are able to prosecute, but they cannot never be prosecuted, as presented by Mr. Alex. And you also said it yourself that maybe to my next point, to say that, of course, when we signed or ratified or agreed to be members of such institutions, and like any other institution, especially from our vulnerable position as African countries, we are compelled because they present, in most cases, they present a problem. So as a president, they'll say, okay, look, should there be a coup, you won't be able to defend yourself. And us, as the ICC, with our own laws, would be in the position to protect you. So they present a problem. And once you see a problem, they put it there and they say, we also have a solution for you. So you are compelled, you are forced, because you don't want to see yourself, to find yourself, because remember, if you don't agree to be part of that, like it has been presented, they will drive the coup. We know that wherever there are those wars, there are people who are driving those wars. But also, last point to say that we was talking about the president from the Senegal who has been prosecuted. It was said again, people are saying they are not prepared to celebrate because they want the real people to come out. And they know that the US was also behind this. But only, of course, because it's been targeted, one face has been raised, only that person will be prosecuted. The real people are not being prosecuted. So that's the things that I wanted to do, to present. But also what we are waiting from you. Thanks.
Please, if you do say your comment will be short, make it so.
Thank you very much. I think there are two things here. There's moral justice and there's legal justice. And I think in pursuit of moral justice, I think those with real conscience, they will speak and their appeal to moral justice will be higher than the legal justice. As South Africans, I think, being very short-chaired, apartheid was legal. And the legal professionals had to choose whether they are going to apply what was legal by the book or what appealed to their moral conscience. And I think that's what the ICC, it's all about. That's what this issue is about. It's about a system that needs to appeal to our moral conscience. And I think it's for everyone to see. So now you cannot have a flawed system being utilized to find the real solutions. It's not going to happen. My question to our African delegate on the panel, you've articulated quite clearly how the sequence of events led to former President Gbagbo in this situation. You never mentioned AU being involved in terms of assisting Ivory Coast when the French failed to come and assist. So I want you to please elaborate on that. And very lastly, currently, America has about over 7 military bases in the continent. And out of that 7 military bases, they've got over 40 countries where they've got military presence. With what you have actually articulated to us, should we be worried as Africans? Because I sense that that trend could precipitate and really come to that very same conclusion. Should we be worried, and what would be your advice to the African Union in that case?
Thank you very much. A couple of other hands have popped up. I'm going to take 2 more and then allow the panelists to respond and then go to a second one. Gambesa?
Yes. Professor, thank you very much. You said Africa is at the front line for the quest of independence, and you're right. You're right because 70% of the budget of the African Union is coming from the European Union. You also said the ICC is not international. And again, I want to agree with you because I know that the first prosecutor of the ICC, Ocampo confessed to a French official that all the investigations regarding Côte d'Ivoire and the ICC were financed by France with the instruction that only Gbagbo's side should be investigated. And also, we know that speaking to a Central African politician, the current prosecutor, Bensouda, said that there's nothing in the case of President Gbagbo, but it's only a pressure from France. Now my question is that if lawyers can be controlled by only one president of a country member, are we right to say that we still have justice? Because somebody was comparing, my friend here was comparing the case of ICC to the apartheid moral situation. I don't think it's the same here. We have the rules that are broken here by France. The rules are broken because they've asked the ICC to keep President Gbagbo in detention until Ouattara finishes his mission. That is what the truth is. And I want to say this last thing because there's a lady called De La Park, Natalie. She came openly to former President Mbeki and apologized on the case of Côte d'Ivoire. That was in London. She now works with Mo Ibrahim Foundation, but she was the #1 anti-Gbagbo during the Ivorian crisis. She said, Mr. President, I want to apologize because on the case of Côte d'Ivoire, you were right. And she said, I was there, I was present when France was instructing Ocampo to keep Gbagbo in detention until Ouattara is ready. So it's clear that there's no justice there. There's no rules there. We are under the control of one president or one country. Now, what do we do?
Control of
What do we do, knowing that Africa is not independent? Thank you.
There was a question in the back. You.
Oh, thank you. My question is to the panelists: what can be done to make the United States and those countries to be subject to the jurisdiction of the ICC? Because that seems to be the main complaint, that they are not subject to the statute. And my comment is that in the case of Sudan, which was not a member state, and Mari will correct me, it was the recommendation of the United Nations which commissioned a special commission to do the investigations. And then it reported then to the UN, including the panelists included lawyers from various countries, including a lawyer from South Africa, Dumisani Ntsebeze. And then the UN then tabled the report to the Security Council. Then jurisdiction was then assumed in the case of Sudan over President al-Bashir and the others. Now, as Africans, what stands between the victims of genocide and other crimes against humanity is firstly that some states do not have the mechanisms to prosecute perpetrators of such violence. And in others, even if they have the institutions, they don't have the resources to conduct the investigations and then bring the people to book. And as I understand it, it's only then that the ICC assumes jurisdiction, because domestic systems do not provide for that kind of resort for the people. And then lastly, on the question of the victims, an anecdotal story by George Bezos is that as human rights lawyers under apartheid in South Africa, when they represented people, they were sometimes criticized for legitimizing the system. And his answer would be, the day that the victims, the accused, and their families say, I must not represent them because I legitimize the system, I will stop. So the victims of crimes against humanity and genocide want justice. And it is our experience, and South Africans as well, that when there is a resort to justice, it sometimes matters less whether it's domestic, regional, continental, or international. Thank you.
Thank you. Quite a number of questions. I'm going to start on my left and go round. If you have any question or comments that you would like to address, Morag?
Well, to quote George Bezos again, we must always have faith in our courts, because at the end of the day, a tribunal where you might get justice. Of course, if this tribunal, as has been suggested, is inherently biased, that is a grave problem. And there is no independence in the International Criminal Court. If it is merely, as has been suggested by other panelists, an instrument of certain powers, well, I'm not able to refute that or begin to try, but obviously I've tried to give certain perspectives to I suppose it comes back to how does one get the United States? I think Britain is a member. So is France. So technically speaking, the Prime Ministers of Britain and France, the President of France could be invited. And I believe that there might be investigations in respect of their conduct of some of them. Is that right? Yes. So that it could be possible that if Mr. Tony Blair puts foot in the wrong place and will be arrested one day. Interesting to see how Britain reacts. Maybe one has to be tested and see how in fact they would react. So in that sense, yes, I agree. I think that one has to keep trying through the courts. Maybe one Chief Justice.
Okay.
Thank you. My good friend and teacher, Maître Jacques Vergès, told me that there is two concepts of justice, of conducting trial. The first concept is the trial as an art. And the second concept, conducting trial as a war. I think that the ICC is definitely take a stand of conducting trial as an art, namely theater. Because we have quite a lot of interesting false indictments against real criminals to make them only to acquit them later. So to bring some judicial sanctification to their crimes. So I think this is already reality in ICTY, and because I know that most of the staff of ICC came to from ICTY came to ICC, I expect some more theater in ICC in this regard too. Concerning the question you asked about impunity, I agree with you. It's really important, talking about current situation, to remember that there are certain criminals and we need to think what to do with them. But I very much doubt that we will be right bringing the problem of impunity of individuals to the level of international justice. Because, by the way, another example, when we are misled ourselves, we are calling the situation happened last June in Johannesburg, here, or the African Union meeting, as al-Bashir saga, or al-Bashir case. Everybody say this because it's convenient, but how wrong is it? Because it's not about a man called al-Bashir. It's not a personal case. And I think in this conversion of the name, there is a big sense when people are trying to make us think that this is a case about person, individual. It is not. It is a case about President of Sudan. And the President of Sudan is a manifestation of state sovereignty. So we come again to the matter of destruction of international law, when people try to make us to believe that there is no immunity anymore of the head of states, meaning no state sovereignty. About immorality, the second question was not asked to me, so I skip it. The third question is about immorality of what we are witnessing in international criminal tribunals. It is indeed immoral things. For example, already during the trial of President Laurent Gbagbo in ICC, which started in January, the prosecution, right in the courtroom, confessed, yes, we have an evidence that French troops fired during the coup against Laurent Gbagbo. We have this evidence. Where is the prosecution? Where is the investigation? So sometimes they even demonstrate their immoral approach to this case and many other cases. How to bring USA to ICC? There is no legal ways to do this. Of course, we could arrest President of United States while he will be on some summit in South Africa, if your organization asks us to do this. But it will be very illegal. So because look what is going on with all these referral situations to Sudan. When we heard that situation in Sudan was referred to ICC by Security Council, it sounds for us perfectly legal. But if we try to look deeper in the situation, we realize the Security Council acted not according to the United Nations Charter. It acted against ICC statute, but Security Council is not member of ICC statute. This institution could not act, but it sounds legally until we just try to look deeper in the situation. So sometimes it's not for the judges to decide, but also for us. Finally, about your question, To tell you the truth, I forget the question, but I written my answer. So I think you will recognize to which question it is. When we are talking about international criminal tribunals, even when we know all the problems with this, we still believe that it is a court. But if you look into the evidence presented in this court, it's a disaster. And we have a big problem between the demonized person in mass media and the result of the trial when this demonized person brought to the trial. Let's take a sharp example of Charles Taylor. He was called by all media as a criminal. He brought to the court. And what was the testimony? Naomi Campbell, the star of I don't know what, she came and gave an evidence that while she was in South Africa, somebody knocked to her hotel in the night, gave her the diamond, and left. And she said, "I believe that it was from Charles Taylor." So the court based its judgment on such a situation. And then one of the judges said, "I don't know where this judgment came. I never be consulted with drafting this judgment." And the judge was just eliminated from the bench. And by the way, how interesting it was that this judge was not turned from the zero one to the real one when the real judge was already elected to ICJ. So she must leave the bench, but she didn't. So many things. My case of Vojislav Šešelj, Professor Vojislav Šešelj, 30 witnesses right in the courtroom said we were threatened by the prosecution to give false evidence. Nothing done. 30 witnesses. So the judges just nothing. Okay, President of Yugoslavia, Slobodan Milosevic, he called by mass media as a butcher of the Balkans. Everybody knows that he's a criminal. During the trial, right in open session, one of the witnesses confessed that he was tortured by the prosecution to give false evidence. If you want to verify my words, just go to read the transcript. It's there. But mass media do not report to such a thing. So we have a very big problem with still believing somewhere deep in our heart or somewhere else that these courts are real court. They are not. Unfortunately, I'm very sorry to tell you this, but my experience shows that this is just so disastrous experience that we not only must withdraw from ICC, but construing our African, sorry, I'm saying our African because I feel African.
I was going to call you to order because I'm African.
Last word. That if we come to the creation of African court, we should learn all these lessons from the ICC and not to rebuild them, just putting the African judges on the bench, but repeating the same problems and defects.
Thank you.
Yeah. Maybe I'm going to speak in French and you are going to translate,
yes,
or if you want. Okay, maybe I'm going to begin in English and after finish in French. In my point of view, we have to pay attention about what is going on right now in Africa. We are in a process of recolonization of Africa. It is what we have to understand right now. And then the ICC is a gun in the hand of the countries who want to recolonize Africa. And then if you are a criminal and you are linked with France or United States, you become non-criminal man. But if you make a policy who does not agree with the policy of France or United States, you become a criminal. And then they try to use the ICC like a weapon to remove you from power and to put you in jail and put another person who can do their policy. Yes, for example. And then if we don't pay attention, the ICC will be a gun in the hand of North countries to recolonize all of our countries. in the case of Cote d'Ivoire, when Laurent Gbagbo gets to power, his own goal is to remove all the agreement between France and Cote d'Ivoire. It is the same problem of all the countries, Francophone zone countries. It is the same problem because it is the same agreement. And if right now all these countries are poor, it is because of this agreement. For example, in Cote d'Ivoire is the first producer of cocoa in the world. The first producer. It is like oil or petrol in every kind of countries in Middle East and every kind of countries. But the part which belongs to Cote d'Ivoire is 20%. The 80% belongs to French companies. This is the reality. And when you want to change this policy, and then you become a criminal. And the ICC come, and the rebels come. And I remember one of you asked me about the army, the French army, European army in Africa. These armies are generators of rebels and coup d'etat since the independence of African countries. They are not there to protect the country. They are not there to protect the continent. They are there to generate rebels and coup d'etat if you don't make the policy that they want. This is the reality. And then, in my point of view, we have to remove all these armies and create a federal army. Because we have AU. We can create a federal army. And then all the countries can make a policy which is good for their population, not a policy which is good for France or for the United States. It is the only condition. And the second thing that we have to do is to create a federal court, a federal court. If we have a federal court, we can identify the criminals, and who is the most provider of criminals in the world? It is United States. Everybody knows. But United States is above of the Rome Statute. All the main criminals in the world are above the Statute of Rome. What is this international law, which is not equal for everybody? The first thing that we have to do, if we want an international law, it might be equal for everybody. No one can be above. If you are above and you are linked with a criminal, this criminal becomes a non-criminal, and he is also above the Rome Statute. In the case of Cote d'Ivoire, everybody knows the role of Ouattara in the terrorism against Laurent Gbagbo, in the attack of Cote d'Ivoire, because he is linked to France, he is linked to United States, he is above the law. He cannot be punished. We cannot talk about impunity in the case of the ICC. ICC is not there to punish criminals. He is there to protect the criminals linked to United States or to France. This is the reality. And that if we want to be independent, we have, first of all, to remove all these institutions and to create our own institution. Then we can be independent. And some asked about the role of AU in the African, in the Ivorian crisis. AU, who are members of AU in the case of West African countries? All the countries in West Africa, member of AU, are also linked to France because of the agreement between France and all the countries around Cote d'Ivoire. If they are linked with France, they cannot be independent. They cannot make their own policy. The agreement of Rome Statute, it was part of the agreement between ACP countries and AU countries. It was a part of the agreement. And then they signed, the African countries, they signed the agreement because they hope to get money from European Union. They didn't think that they are signing for criminal court. For them, they are signing to get money to develop the country. But they forgot that in the agreement, there is an article who says that if you violate the law, you can be persecuted. This is the situation. And then, first of all, if today we ask to all the African people who agree with the International Criminal Court, I think that most of the citizens will vote against this law. And what is this law? Which is not legitimate, because he has not been voted by anybody in Africa. They didn't put it in vote. It is not a democratic law. It is it is a law it is an agreement between the head of a state in Europe, because I don't remember that in Cote d'Ivoire, for example, when they say that we are member of Rome Statute, we vote for that. Nobody voted. Well, first of all, if we want a law which can work, the first thing that we have to do is that this law must be a democratic law. It is the first thing. The second thing is that nobody can be above of this law. If these two conditions are together, and then we can talk about a legitimate law which can be applied to all the countries. But right now it is not the case. And then for me, we have to pay attention. If we want to be free, we have to be very, 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 very careful with the ICC, because it is a weapon against freedom in Africa.
Thank you. I am about to be. Thank you very much. I'm about to be either as popular or as unpopular as a dictator, depending on which side of the fence you're on. But it's 8:45, which is 15 minutes over the time that I had extended, which means we'll have to end the panel discussion here, but we won't have to end the conversation here. I think there's quite a lot of things that need to be discussed, and this is a conversation that will be ongoing. Some of the things that have come up from the speakers, which was interesting, from Dr. Don Bello, was speaking about a federal court and then pointing out that the African Union is not independent because the member states themselves are being puppeteered. And then also coming from Alex, Professor Alex, which was speaking about the president as the embodiment of state sovereignty, and I'd ask the South Africans in the audience what they think about that. Don't answer. And then speaking to what are the African solutions to the African problems, and how would those be, and how would those play out, be it domestic, be it regional, be it international. This is the last you will hear from me, but before that, first to thank our panelists, if you could all please give them a hand of applause. And I will hand over to Noreen Teng, who will close the session for us.
Good evening. My name is Dr. Maureen Tom. A number of you in the audience would know me from the Thabo Mbeki Africa Leadership Institute and the Thabo Mbeki Presidential Library. But my role tonight, I've been requested by the CEO of the Thabo Mbeki Foundation to extend a vote of thanks at this ceremony, at this event tonight. It is indeed, as you see from the motto of the Thabo Mbeki Foundation, the foundation is really about, we really are dedicated to Africa's renewal and Africa's renaissance. And the work that we do, including the annual lecture, that I see a number of familiar faces that were indeed there on Friday, and Otilia herself being one of the panelists. And I met Prof. Alexander there as well. All the members of this panel look very familiar tonight. They were there as well. That exercise, or that event of Friday, being the annual Thabo Mbeki Africa Day lecture, the 7th of such an edition, really is about what President Mbeki has always been about when he was in office, and the work that he continues to do after office as well, which is looking for ways in which we can contribute towards the renaissance of the continent of Africa. We are most thankful for you to being here tonight. As Otilia has correctly pointed out, there are perhaps many things we could have chosen to do tonight, but you chose to be here and spend this time with us. And I want to say that the quality of the discussions today were really of such a high quality. I was highly impressed sitting there in the audience. Some of you might not know, I'm a scholar of international law myself. So when I have opportunities like this, and I guess this is really the joy of working for President Mbeki, is that in the nature of the work, you get exposed to this kind of things, you know, to this level of discussion, to these topics, to the need to sit down as Africans to look for solutions for the continent of Africa. And the conversation or the discussions tonight were really absolutely enriching. It was a very balanced panel, in the sense that although we had 2 against 1, on the 4 against argument for the ICC and the continued participation of the African Union in the ICC, certainly I want to thank most sincerely the panelists for taking the task so seriously. Clearly you prepared very well for this conversation. Your articulation of your position, I will not repeat anything. Otila did very well in moderating the discussions. I just want to say that very clearly your articulation of your position shows that, you know, firstly, obviously, your real conviction in the first instance about the view that you hold in the first instance, but secondly, that you took us seriously enough to make time to prepare properly for your presentations tonight. So for that, we thank you very much. And Otilia, thanks again. As I said when we met, I said I was so wowed on Friday when you were one of the panelists at the Africa Day lecture. The way you were very articulate and really clearly showed your deep understanding of the issues and being as a participant. So tonight again, you have impressed me greatly in terms of your moderation of the panel. We thank you most sincerely for that. Members of the audience, thank you most sincerely as well for being here. Weber Wenzel, I see that, well, in absentia, the senior partner was here first, did the introduction, Christo else. I want to thank him. Octavia, who was here as well. And other members of Weber Wenzel that are not here, I just want to say thank you so much. The provision of the facilities, and obviously the opportunity also and the collaboration with the Thabo Mbeki Foundation is really appreciated, that it is possible for us to meet and continue to have these conversations. And yes, those that are here, may I continue to see your faces in the kind of discussions we hold from time to time, whether it's here in Johannesburg, whether it's done by private organizations and law firms like Weber Wenzel, and whether it's done by academic institutions. It would be really an honor, and we really appreciate your contribution and your dedication. Thank you so much, and good night.